Good morning. Wanted to share with you an incredible shiur that we actually gave on Shavuot night, which has to do with, can a person posthumously have a child? Which means after they already deceased, can they father a child? So listen to this. In November 16, 2016, there was an article in the Times of Israel. Listen to the article, and then we'll go through the halakha, obviously, trying to understand what exactly is going on. The article starts with the hardest thing in the world is to lose a child. And it says that an Israeli couple wins the right to produce and raise grandchild from fallen soldier son's sperm. So let's see. Kfar Saba, like many couples in their early 50s, with grown children, Irit and Asher Shachar look forward to becoming grandparents in the near future. The Shachars, however, plan on welcoming their first grandchild in a highly unconventional way. Ever since their son Omri, a captain in the Israeli Navy on active duty, was killed in a June 2012 car crash at the age of 25, the couple has fought the state to gain the legal right to produce a child from their son's posthumously retrieved sperm. The Shachars plan to raise a child themselves, so they started a hard-fought battle. It ended this past September in a precedent-setting ruling. The Petah Tikva family court granted permission for them to raise a child created from their deceased son's sperm and a purchased female egg. The embryo would be carried by a gestational surrogate. So you have the egg donor, right, is somebody else, the surrogate, somebody else. The sperm is coming from their own child, which had no children, which is the fallen soldier, and they are going to raise the child. So look how many people are involved, right, in this circle. The court's decision is believed to not only be the first one for Israel, but also for the world. Since 2003, Israeli regulations have allowed for posthumous sperm retrieval for the purpose of later insemination, or IVF, by a surviving female partner, which means if right now a person's married and then they fall in battle, the state of Israel from the year of 2003 permitted already taking the sperm for the IVF of the wife, the surviving female partner. In the last decades, there has also been numerous instances of parents legally providing their sons to single women, or even to become pregnant. In those cases, the women were the biological mothers of the children. They raised the children, and the parents are supposed to remain in the picture as age grandparents. Despite the September ruling, however, the state is currently preparing an appeal, right? Just like the unusual circumstances of the desire to be both grandparents and parents to these offspring. In the meantime, the court has issued an injunction preventing them from accessing and using the stored gamete. As soon as the injunction is lifted, we are going to move on things right away. They said they're going to move to right away. Okay, fine. Then they come and they said that they've already spent more than $130,000, right, on legal fees and fees, doing all these things. They said that they're willing to sacrifice it, right? Okay, fine. Now it says over here, it's an unprecedented court decision, but not a legal precedent. While all professionals, experts, the Shachar, they say they approach were sympathetic to their plight, only some were willing to support their case. One of them was a philosopher who related the bereaved parents' pain on a personal level. Why? He was the co-author of the IDF Code of Ethics and himself the father of a fallen soldier. So he went and he said, at the end of the day, he said, right, this is you're planning orphanhood. You're planning them to be an orphan. He says, no, but it's a fragile in relation to children from normative families. So the judge wrote, there's nothing unacceptable about the way that they choose to deal with bereavement and the request to give their late son descendants and raise their own. Why? Because they wanted to say that it's not any different than any other type of a family. Because since they were looking to raise the child themselves, it's not like somebody else. Meaning like this, and this is what I was asked on the night of Shavuot. They asked me, Rabbi, what happens right now if they weren't going to bring up the child? Or they felt that, let's say that these parents were in their 60s, 70s. Would they have been permitted? So obviously the court wouldn't have given them the permission. And this is a secular court. We didn't even get to the halakha yet. You understand? But the court would not have given them permission. So since they wouldn't have given them permission, it all depends on the circumstances, obviously. Now, as the court's decision in favor of the Shachars, right, pushes, right, the bioethical envelope here in Israel, the world looks on with interest. Some countries, they permit this, right? When the deceased has left a written, meaning he wrote it down, he wants it. Others, such as France, Germany, and Sweden, they ban it outright. In the US, the laws in this regard depends on state to state. And key legal cases have centered more on the inheritance of social security consequences, right, rather than on the permission for its use. Okay, so according to Harvard University law professor, right, Eglin Cohen, a leading expert on the intersection of bioethics, right, and law, there are many issues to be considered in the case of the shachar. These include invasion of the body, the right or not to procreate or be a parent, harm to the children, right, rights of claims of grandparents, intents of the deceased. So there's a lot of things what to deal with over here in this situation. While the Cohen preferred not to comment on detail on this, he did tell them that he was taken aback by the Israeli court's decision, right? He says, listen, there's a lot of different, halachot here involved also that we wanted to find out, but then we're going to try to understand. Okay, so this is all the story from a legal point. Now we're going to start with the halachic aspect. Okay, so if you remember, we just mentioned this was the story of the times of Israel. Okay, and now we're going to ask, would halakha approve of such a practice? Meaning, would the halakha approve that they're allowed after death to come to take out the semen, right, and then to do all these things or not? Is it permissible, right? Can you take out the reproductive material after death and then use it? So now, again, this is only going to speak about the halakha of extracting the sperm from the deceased, right, of the male body, without the entire concept of IVF and, for married couples. We're not getting into that. We're just speaking about the fact of taking out the semen from this human body after death. A second halachic question relates to that which we're learning in Daf Yomi. We're learning in Daf Yomi the halachot yibum. So the question is, the Torah requires that a married man that he dies childless, his widow has to marry the brother, right, or be released, right, by doing chalitza. So now the question is going to be, nowadays usually they do chalitza more than yibum. There's a Ramah that maybe the yibum is not 100% l'shem shamayim. So therefore, if you have that it's not done l'shem shamayim, it's not done for, if basically he was doing it just because he wanted to be with his sister-in-law, so then it could be there's even a problem with karet. So therefore, what happens is that if, let's say, they would do this, and this guy was married, he was not married, but let's say he was married, and they did this, and they had a child through this, which means they took a sperm, they gave it with an egg, they did a surrogate, they had a child. Would this now exempt his wife from ibum or chalitza or not? So that's another question. Okay, so we're going to speak about both questions, and we're going to go little by little. So first of all, we're going to learn a concept in halakha which is called that a deceased is a sur b'hana'ah. A sur b'hana'ah means that, are you allowed to derive benefit from a human corpse after death or not? The Gemara Masechet Avodat Zarah, Kaftet Amud 29b, establishes that you're not allowed to benefit from a human corpse. The prohibition is derived from the textual parallel, from the communication, the Gezerah Shavah, between the Torah's death account of Miriam, where it says, "V'tamot sham Miriam," the Miriam passed away. Okay, this is going to be in coming up parashas, right? And the command of Eglah Rufa. Okay, so in the Eglah Rufa, we know that a person was killed. Okay, and we don't know who killed him. We don't know who the murderer was. So we measure which is the closest city, and whoever is the closest city. So what happens is that we are going to go over there in the closest city, and the bedin come and they bring an Eglah Rufa. They bring this egg in, right? And they have to chop off its head from the back. That's why they don't do regular shechita from the front like normal. They do it from the nape, from the back. That's called an Eglah Rufa. Since it says by Eglah Rufa, v'arefu sham et ha'eglah, and it says v'tamot sham Miriam. Just like by the Eglah Rufa, once you kill this animal, you're not allowed to have any benefit from the human body, from the animal, right? You're not allowed to have any benefit from this animal. You just did an Eglah Rufa, that's an atonement for the betin, saying, we didn't have any, our hands are clean of blood. But what happens is that just like over there, the Eglah Rufa, you're not allowed to benefit, so to the human body, you're not allowed to benefit. So sham, we use the same terminology by Miriam, which is a human being, and the same terminology by the animal, Eglah Rufa, you're not allowed to benefit. So therefore, the consensus among the poskim follows straightforward reading of the Gemara, which means that benefiting from human corpse constitutes an outright biblical violation. Okay? Nekuda. Okay, it could be that maybe according to Rambam Banan, but this is the the Chida rejects. He says, no, okay, fine. Okay, so it's a biblical prohibition. So seemingly, if you want to take the sperm from a deceased body, you're not allowed to. Why? You have a prohibition, right, to come to to use the body. You're not to benefit from the body. Okay? And maybe you're going to argue that 1 second. Maybe the prohibition of deriving benefit is because of Kavod Hamet, is you want to give respect to the deceased, and that the prohibition would thus not forbid, right, making use of somebody's body in order to come, right, and in order to give him honor. So in the case under discussion, right, particularly if the deceased did not fathered any children, right, during his lifetime, so producing children from his reproductive material ensures the legacy. So he's not going to be left behind. So it's not a disgrace, the opposite. It's for his kavod. So maybe you're going to tell me, when did the Torah prohibit it? Only if for the kavod hamet, for the respect of the deceased. But here, the opposite. This is the respect of the deceased. That you're giving him a legacy, you're giving him a continuation. So maybe over here, it should be permitted. Several sources, though, however, indicate, on the contrary, that the prohibition of using a human corpse has nothing to do with the dignity. Rav Yosef Engel writes that a living human being is endowed with sanctity, and the loss of the sanctity with a person's death results in something which is called a contamination. So therefore, he says the prohibition of against using, according he says, is nothing to do with between the honor and not honor. He says it just doesn't exist. You cannot come and get out of this exemption. Rav Moshe Feinstein rules in the Igrot Moshe that a deceased person's remains may not be taken for the purpose of medical research. Meaning sometimes they ask you, Rabbi, after 120, can they use the body for, listen, he's helping the human race. Maybe now they're going to use the body, and then they're going to find cures for certain things. And then there should be no problem with it. It's a medical research. Even if this was explicitly stated his wish during his lifetime, a person does not enjoy ownership over his body. Remember this. This, by the way, Mauricio, you could always connect to cremation and other things as well. That there's even worse of it as well because of Tchiyat HaMetim and further on. But even a person does not own their body. He explains their Moshe Feinstein. The human body is given to him as a loan, as it were, to use during his lifetime. After death, the body in its entirety must be interred, regardless of the deceased's wish, and the contrary, which means that it doesn't matter. So he says clearly then honoring the deceased person by producing will not be permitted at the end of the day. Another important concept is that it's important to distinguish in this regard between two distinct prohibitions. One prohibition is nivul hamet. Nivul hamet means disgracing a corpse. The Rashba writes that although it is generally forbidden to tamper with a human corpse out of concern for the deceased's dignity, post-mortem procedures are allowed when this serves the purpose of preserving the deceased dignity. The question addressed by the Rashba relates to procedure to hasten the body's decomposition, so it can be transported for interment, right? For interment in the deceased specifically chosen burial site. Such a procedure, the Rashba says, is permitted, since the prohibition of nivul hamet is disgracing the deceased. Thus, doing this is going to be allowed for his honor. This is quite different from prohibition against deriving benefit from a corpse, which means two things: disgracing the body, and then there is, which would be permitted if it's not disgracing the body, and it's for the body's best. And then there's benefiting from the body, which that has nothing to do with one another. So there's two different halachot. So for example, the Rashba had the question, what happens right now if they wanted to transfer the body? And in order for the transferring of the body, that the body needed to decompose. So now they were going to cause the body would decompose in order that it could transfer it from one place to another place, where that's the final burial site where he wanted to be buried. So says the Rashba, the fact that it's going to be for his honor to do his will, to go to the final burial place, it's going to be permitted. Why? Because there's no problem of nivul hamet, but that has nothing to do with the avirah of benefiting from the human corpse. There's two different halachot. There's the halakha of disgracing the human body, that it could be that if it's going to be for the betterment of it, that it will be permitted. And then there's benefiting from it. But now there's going to come another important concept, which is one of the prominent 20th century posek Rav Isser Yehuda Antonin, right? In Minchat Shlomo, this is also discussed, right, in the Minchat Shlomo. He came and he permitted transplanting a cornea. The cornea is obviously the inside of the eye, taken from a deceased person into the eye of a live patient. So one more time, we're not talking about all organs. We're talking about the cornea, that the inside of the eye was taken and implanted into a live patient. This does not violate the prohibition against benefiting from human corpse. And the reason why is because he said the prohibition applies only to a dead body part. Once the cornea is implanted within the living patient's eye, it is resurrected. It comes back to life, as it were. In the sense that it again becomes functional. So Rosh Hashanah, he commonly suggests that this could be actually the case in Trumot. There, it's talking about a sapling, which is a young tree, right? A small tree designated as Truma, which goes to a Kohen, that became Tameh. But then it was planted, right, in the ground. The planting has the effect of divesting the tree of its status of impurity, because now it's born again. It's like reborn. So therefore, in a similar way, the cornea regains its living status by just implanting it into the eye of a living human being. And therefore, it's no longer prohibited because of benefiting from a dead body. So there's such a concept that you're resurrecting the organ. Now, this doesn't apply to every single organ, but it does apply to the cornea. And therefore, you wanted to say that it's going to be permitted. This rationale could also apply to insemination. The semen will not be any different, right? Why? Even though the sperm is taken from the corpse and it's not allowed to be, you're not allowed to benefit from it, the second that it's injected into the woman's uterus, it becomes functional human organism again. And then again, it should be permitted. However, just like the Rav would approve of this post-human procedure, Rosh Hashanah did not accept his view. Right? Why? He argued that if benefit from something is allowed to be forbidden, then transforming it into something that is no longer forbidden is also prohibited. Why? Because that's the concept of which means like this. I'm going to ask you a question. You have meat and milk is prohibited in the Torah, correct? Fine. Can I come now, right, and pour milk into a pot of meat? And I'm just going to make sure that there's more meat than milk, 60 times the meat than the milk. So it's going to become a null. Can I do that? Obviously not. If it fell in, so then that's something different. Then I go into the halachot of bitul, of annulling. But I cannot come to Chatzila, but it's not. Imagine, I'm going to come to your house, right? Imagine I'm going to come to everybody's house. I'm going to pour a little bit of milk. I'm going to say, don't worry about it. You still have 60 times. It's going to be tasty. You meat and milk. It's good, right? But it's batel. No. You're not allowed to annul an isur from the beginning, from the get-go. So says Rosh Hashanah, this is the exact same thing, right? Why? Because if you have something which is prohibited, and now you want to take it, and now I want to annul it to make it permitted, that's a sur. So because of that, Rosh Hashanah or argues on Rav Antonin, he says, I'm sorry, it's prohibited. Therefore, if the benefit of the food is forbidden, right? I cannot trigger a bitul. So the same thing, resurrecting is going to be prohibited. So again, one more time. The first reason, right, we have to always remember what we're talking about. Here we're talking about taking out the semen. So we spoke about, the benefit, you're not allowed to benefit from human corpse, right? That's they learn from Gzera Shavai. It's probably Doraita. Even though somebody wants to say it's Rabbanan, it's probably Doraita. Then we wanted to say, okay, can you use it for his honor? So Moshe Feinstein said, no, you're not the owner of your own body, and therefore, even if it's going to be the will, no. The Rashba wanted to differentiate between honor because of Nigulamet, which means you're going to have to disgrace the body, or because of benefiting from the body. Benefiting from the body, no. But disgracing the body for its honor would be mutar. Okay? Another thing we spoke about now was resurrecting the body part. Rav Unterman wanted to permit, okay, because he wanted to say that's what he wanted to say over here, that it's resurrecting now. It's coming back to life and it's permitted. But Shlomo Zalman said it's asur. Why? Next. What about hair and skin from a human body? Imagine right now a woman passes away. She's got beautiful hair and she wants to donate it to Chai Lifeline or to all these children, right? And she says, listen, it's going to a mitzvah. Can she do that or not? Hair or skin? So it says here another possible argument that could perhaps be advanced for permitting posthumous fathering is that maybe the sperm is actually like an extraneous matter, and it's not really the part of the deceased body. It's like the hair and the skin. What does that mean? Right? There's a machloket in the Rishonim. What about hair from a deceased person? This was already a machloket in the Moraim, the Gemara and Arachim, and the Rambam permits using the deceased person's hair. However, though, even though the Rambam permits it, Shulchan Aruch says it's prohibited. So you have again machloket the Moraim. The Rambam permits, but Shulchan Aruch prohibits. He says that stringent position, forbidding even the hair taken from a corpse. So then we can actually come and say, so one second, it's not less than extraneous than the hair. So therefore, Shulchan Aruch said it's prohibited. It's prohibited. But maybe you're going to say that maybe the sperm taken from the deceased, right, is to the skin taken from the deceased, which some Rishonim permit for use. Tosfot and Nida, they raise the possibility that since a prohibition against benefiting from human corpse is rooted in the implied association between the corpse and the korbanot. Remember, the human being, which was like the sacrifice, it does not apply to skin because the skin of the sacrifice of the sacrificial animals is permissible for use. Once the blood has been sprinkled, they could use the skin. So just like the skin of the animal that is a korban of a sacrifice is permitted in use, so therefore Tosfot says that the skin of a human corpse should also be likely permitted. The theory is also proposed by the Rashba in his Tshuva. So what is the halachic status of the skin? The Rishonim come and they say, it's based upon the Gemara Masechet Chulin. The Gemara establishes that although skin of a deceased person is not strictly speaking considered tameh, the rabbis made it tameh in order to prevent people from using their skins of their deceased as carpets. Did you guys just hear what we just said? Which means that the rabbis went and prohibited, put tum'ah, impurity, on the skin of a human body, even though the skin is not tameh, in order that they shouldn't skin their relatives when they pass away and use it as a carpet. Right? That's why they had to prohibit it. Incredible. The implication. So now, according to what we just mentioned now, it comes out that even though the rabbis, they had to make the skins prohibited because if not, they would use the family members' skins as carpets. So the Rashba came in and said that he brought a proof that the skin taken from the deceased is permitted for use. But the Rashba says it's not true because there we're talking about foolish people who are more deterred by the status of tum'ah, right? That it's going to be it's tameh, than actually benefiting or not benefiting. The Ramban in the Lan add other explanations as well. That the Gemara is speaking about people who would spread the skins of deceased loved ones and eulogize them in front of the skins. So therefore, the concern with that time was that they're going to use them like as it wasn't mamash, so therefore it was a little bit different, right? Okay, fine. Anyway, to this we might add the fact that we see in the Shulchan Aruch he forbids using even the hair. So therefore, if the hair is forbidden, certainly the skin, which is more integral to the body than the hair, is also going to be forbidden as well. So that means in conclusion, right, there's not really much room for leniency because of the hair and the skins, because Shulchan Aruch prohibits, and therefore obviously the sperm should probably be the same thing. Next factor, shelo kederech hana'ato. Are you allowed to benefit from it because it's not the normal way you benefit from something? Which means like this. Another factor to consider is when maybe you could be permitted to extract the sperm, is because the Gemara Masechet Psachim says any isur in the Torah, you would never get lashes if you don't do it the normal way of usage. Okay? So therefore, when the Torah prohibited certain things, it's only the normal way. So the Gemara clarifies that we're talking about, for example, forbidding consumption. So when it prohibited eating, it's only eating under normal circumstances and not just consumption. So if a person came and they consumed in another way, in a not normal way, whether it's pig, whether it's a soul, but they don't get lashes. Okay? They don't get lashes. So the question is, maybe you're also saying it's not kederech hana'atan, it's not like the normal way of benefit. So therefore, if you're outside the temple wall, you're benefiting from a chain. So is that considered like an abnormal benefit that would be permitted? You're benefiting from the Bet HaMikdash. Yeah, but it's not something normal. Okay? So basically, there's a whole question about this here. The Radbaz wrote a response to him about the permissibility of use of mummies for medicinal purposes, concluding that this form of benefit constitutes shelo kederech hana'ato, and therefore it's permitted. Right? And there's several acharonim they actually permitted as well. By contrast to Akiva Eiger in the Shulchan Aruch, he cites the Ginat Radim, and he disputes this position, maintains that all uses of human corpse is prohibited, even non-standard forms of benefit as well. So basically, again, you had another, we're going to say, form or question to add to the equation, which was, What about not the normal usage? Is that permitted or prohibited? Machloket also in the Acharonim. And then the question would be, taking the sperm in such a way is that unusual or not unusual? Well, usually, you could argue that it's still inside the body, is no other useful function other than fertilization. So is it a normal? Or maybe you could say no, that once after the person's death, the body is not anymore reproductive. You could go back and forth. So there's a whole question here about that. Okay, and then there's another question about the Tzvi Pesach Frank. What about corneal transplants? So Rav Frank raises the possibility of considering transplanting a cornea to a live patient also. He says, but when a person dies, his cornea is no longer slated to serve the function of facilitating the vision. On the other hand, one might say, no, the facility is precisely the cornea's purpose. And therefore, if you're going to put it into another human being, that is the standard use. So again, you have a back and forth also to do with the cornea. Rav Moshe Feinstein also just a similar question regarding the transplantation of organs from a human cadaver to a live patient. He writes that although nowadays it's not customary to use human corpse for any other purposes other than organ transplantation, nevertheless, this form of benefits is again shlop derechanato, would be permitted, prohibited. Again, Rav Moshe Feinstein was very stringent that nothing, even unusual, everything was prohibited. Okay, therefore it doesn't help. Okay, fine. So that's the shita of Rav Moshe Feinstein. Another one. Okay, another concept. What about a kazait? We know that many times, whenever we're talking about prohibitions, they always usually have a measure. What does it mean a measure? If you're going to eat pig, chas v'shalom. So eating pig is always a soup, but you don't get lashes unless you eat a kazait. You eat 28 grams, right? You don't get lashes. Why? And there's a whole question about eating less than that. It could be it's a soup because of chatzi shiur from the Torah. Is it less? But you're only having a drop. You're not eating a full piece. You're not eating a piece. You're eating a little tiny amount. So maybe there's a difference between how much are you taking from the deceased. So another argument that may be advanced to permit this procedure is that the volume of sperm taken from the deceased amounts to less than a minimum volume required for the prohibition to be applicable. The Acharonim debate what is the minimum size for an object or substance to be considered forbidden for use. Usually we say it's kazait. To be biblically prohibited, we say it's kazait. Does this rule apply as well to objects forbidden for other forms of benefit? Or is it only on certain subjects? So the Mishnah Elmaleh establishes that if the prohibition is formulated by the Torah as a prohibition against eating, then it's a kazait, even with respect to other forms of forbidden benefit. When it comes to such things, one is not liable for biblical violation unless it's a kazait. Doesn't matter about the monetary value of the object he enjoyed. However, though, prohibitions that are not formulated to do with eating, one is guilty only by deriving the benefit, the value of a pruta, which is the smallest currency, right? A pruta, regardless of the size. So since the Torah forbade it, right, the use, so then that's going to be the question over here. So this is also the view of the Pri Megadim. Rabbi Akiva Eiger disagrees. He says no, the physical size is never a factor with respect to forbidden benefit. Even if the Torah came and said it's going to be prohibited, it's always going to be deriving the pruta. So now, according to this, now we're going to come back to us. In truth, maybe, basically what happens in this case, right? According to this view, it would seem that a portion from a corpse comprises less than a kazait would be permissible for use, since a body part detached from a corpse deemed tameh only if it has a kazait. So this is the shita of the Stechem in the name of other poskim. Khatam Sofer also says that's the same thing. So maybe according to that, right? So maybe it would be okay. So we could permit the sperm because it's going to be less than a kazait. It's for sure less than a kazait. You don't have 28 grams, right? You know what 28 grams is? A huge amount. You don't have 28 grams over here. But we have a question because it could be that the prohibition is against any type of thing, or tumah or hair, anything else. So you've got back and forth. So now we're going to just make an interim summary, right? A summary. We have seen the consensus view amongst people likely forbidden, right? Make posthumously extracted semen. Although this would be permissible according to those authorities to permit corneal transplants, Rav Unterman maintains resurrecting the dead body or the dead organ into a live body would be permitted. And Rav Frank asserts that a small organ such as cornea does not fall under the prohibition of benefiting from human remains, and a transplant may be an abnormal form of benefit. It would appear that a case of a man dies childless, and his wife very much wishes to perpetuate his biological legacy, especially if it's known that this was his desire. Maybe they could rely upon Rav Antum and Rav Frank to allow the insemination of the wife from the husband. So basically, what he's trying to say now is that this is Rav Yitzchak Herzog was was saying, okay, there's a whole thing here. But again, it could be that maybe they would permit it. Again, why are they permitting it? Maybe he's married. The wife wants to use it. This was his wish before his death. It's smaller than a kazait. It's an abnormal way of a transplant. It's dead body organ that when you put it into the live person, it resurrects, right? So because of all these things together, right, again, maybe they could permit and they could rely upon this lenient opinion, even though there's going to be a huge machlok. Okay? Nekuda. This is just an interim summary, even though there's going to be more. Now we're going to go to the next part of the shiur, which was basically, what about chalitza nibum? Remember, we started off by saying the person dies childless and he's married. So the wife has to do either yibum or chalitza. She has to get married to the brother-in-law, or chalitza, that he basically, taking off the shoe, the spitting, this, that, and then she's permitted to go to get married to whoever she wants. So the question is, if they did such a scenario, if they did this, yeah, is that going to now come and permit or prohibit, right? Is it going to the yibum or chalitza or not? Right? Again, the guy dies without children. They're going to take out the sperm after death, put it into her, and now they want to find out, right? And she's going to have a child. Is that exempt of yibum or not? So let us now turn to do with yibum and chalitza. We already explained what is the chalitza or not. So the question is it a child or not? So let's see like this. Conception between intercourse and the husband's death. We did mention this, if you remember, last Friday. That we also gave the shiur on Shavuot night. An incredible Noda Yehuda. The Noda Yehuda says that in the Mishnah Gemara Masechet Yevamot, right, they established that a woman is pregnant with her husband's only child. When the husband dies, she does not require chalitza yibum. So if she's pregnant, she doesn't need chalitza yibum. What happens if the husband died immediately after intercourse? Which means he had relations with his wife and boom, dropped dead. Yeah, now she only conceives, she only becomes pregnant within the next few hours, or within the next 3 days, as we already mentioned. So on the one hand, since the woman was not pregnant at the time of her husband's death, maybe she needs yibum. On the other hand, since the husband already took the sperm and put it in his wife's body, so it's only a matter of time before it's going to fertilize, then she's going to become pregnant. So therefore, what's the halacha? What's the halacha? The Noda Yehuda, he advanced the theory, and he said that a woman is not halachically pregnant before conception. And therefore, if the husband dies before conception, he doesn't have any children, and she needs to do yibum or chalitza, even though she's going to become pregnant tomorrow or the next day, and even though 9 months later she's going to have a child. Okay? This theory is proposed to answer another question. Why? Because the halacha states as follows. Yeah? Basically, the halacha states, what happens right now when a woman gets divorced or becomes widowed? When is she allowed to get married? She has to wait for 3 months.
Minimum 3 months.
Minimum 3 months, 90 days.
So that happens with the widow.
Exactly, 3 months. To know she's pregnant. Exactly, to know if she's pregnant or not. But now Chazal assume that pregnancy can be detected 90 days after conception, correct? 3 months. And therefore they required her 3 months in order to wait. So now the question is, 1 second, why didn't they have to wait 90 days plus a few days? Why? For the delay between intercourse and conception. Even if a woman does not appear pregnant 90 days after the husband's death, maybe she'll be a few days later because she only became pregnant 3 days later, up to 3 days later. If you remember, that was an entire shiur, that a woman could still become pregnant within 3 days, because within 3 days, the semen is still able to conceive, to fertilize an egg. And therefore, why didn't they wait? So they should have never said 90 days. They should have said minimum 93 days, right? Why didn't they do that? Right? So he comes and he says, to answer this question, the Noda Yehuda says that if conception that occurs between intercourse and husband's death does not absolve the woman of yibum, and therefore she's not pregnant the moment that the child died, the husband died, there still means yibum. So therefore, the Noda Yehuda concludes by saying, listen, I love this theory, but nobody ever earlier in halachic literature spoke about it. And therefore, he says it's such a novel theory, it's such a new chidush, that it's not halachic practice. So if a woman's pregnancy is occurring 92 days after the husband's death, she does not need the chalitza. Although it is possible that she conceived, right, only after the child death, nevertheless, the Nabi was not prepared to use it. Even though he said the chidush, he wasn't ready to use it. He still said that she still needed chalitza. It's like he didn't want to come and start. You understand? Like he didn't want to use it 100%. He was like, in a sense. But now, right? If we're going to now say this, right, regarding the case of an only child, the Gemara establishes the widow does not require you, despite the fact that the deceased husband now has no children. The Gemara, but now we have another question, right? Imagine right now, right? The woman comes and, right, and basically there's a question. The question is like this. Imagine right now, a person dies and he has a child. Does he have to do yibum? No. Okay, why? He has a child. If the child dies before the husband dies, does he have to do yibum? Yes. We just learned this, right, in Daf Yomi, I think it was 2 or 3 days ago, right? 2 or 3 days ago, where the Mishnah in Daf Yomi says, imagine right now, right, if the father and the child go to Medinat Hayam, they go to that diaspora. 2 witnesses come back and they say, the husband died first. So if the husband died first, she could go and she could get married to anybody else. Why? Because when the husband died, she had a child. He had a child. Since he had a child, no problem, right? She's permitted to the shuk. What happens if she went and she got married and then they came 2 witnesses said, no, it was opposite. The child died first. So if the child died first, she's obligated to do yibum, which means yibum is not only a child. Yibum is a child that's living at the time of the husband's death. Now, says the Gemara, is an incredible Gemara. Listen carefully. This is going to be the Pei Zayin Mudal, 87a. The Gemara says, what happens now, right? The father dies, right? And he has a child. So the mother goes and she remarries, right? After the 3 months, she remarries, no problem. She remarries, and then the son dies. What's halakha? Technically speaking, she should go back to the original, she should do yibum now. Because if the child died, she should do yibum. Says the Gemara, chidush. Tiracheha darche noham. The Torah is pleasurable. And therefore, in the case which a man died, he left behind a child, the widow remarried. If the halakha would retroactively require yibum after the death of the husband's child, it would create a gravely disagreeable situation. The woman would now have to divorce, right? Because she's retroactively has to get married to the brother-in-law. The second that she gets remarried, that's it. She doesn't have to go back to the original. She doesn't have to do yibum. Right? Yevamot, tafpei zayin amudal. Gemara mefurash. Okay? Now the Gemara is saying, Dirachei darchei noam is relevant also in the case of conception after the husband's death in the converse. The widow, in such a case, has no children at the time of the husband's death. Therefore, she has to do yibum. If we then retroactively revoke the yibum obligation under a conception, this would certainly cause a desirable situation. Thus, in this instance, we should also determine a woman's status vis-a-vis yibum only in the circumstance at the time of the husband's death. So if she's not pregnant at the time, she requires yibum, right? Even though she's going to subsequently conceive afterwards. So they could say that's not true, because the concept of the Dirachei darchei noam was only in this case, but not the other case around. Okay, but now again, one more time, turning to the case of vis-a-vis the insemination of the husband's sperm after death. So then it would be on this theory against the Yonah of Yehuda. According to this theory, the deciding factor is biological offspring is at the time of the death. Since the widow was not pregnant at the time, so therefore she needs to do chalitza yibum, even though she's going to have a child from the husband afterwards. However, though, the Yonah of Yehuda was reluctant to apply his theory as halakhic practice. So maybe we could actually come and say, no, yes or no. So now we're going to go into the people that argue on the Yonah of Yehuda. Who argues on the Yonah of Yehuda? Number one, the Keren Orah. He says, first of all, right, he wants to come and he wants to say, a Kohen's daughter is permitted to eat truma until she marries a non-Kohen. A Kohen's daughter, right, she's allowed to eat truma until she gets married to a Yisrael. Then she loses the privilege. Even after she's widowed, she's still prohibited to eat the truma if she has children. The Gemara says, what about, right, after the husband's death, right, is the same subject as the widow's exclusion of yibum. So the only difference between the two cases is that in the case of truma, the widow regains her right to eat truma if the child dies. Okay? But to do with Yibum, she doesn't have to do Yibum again. Why? Because of the Rachel Rachel. So Rabbi Levonsky writes, if a woman conceives after her husband's death, she's still disqualified from eating Truma because she still has her husband's child. So therefore, you see from here, the conception is what's disqualifying from Yibum. Right? But just like it disqualifies Truma, disqualifies from Yibum. Now we could say no because of the Rachel Rachel. Fine. Then he says another incredible thing. And he says about inheriting the father's estate. He says if a father has a son eligible to inherit the possessions, then by definition, the wife is excluded by Yibum. Why? Because if you remember, we already learned Yibum depends upon inheritance. That's what it said. Yibum depends upon inheritance. So therefore, if the deceased man has a son who can inherit the estate, so for by definition, the widow is not obligated in Yibum. So Mordechai Halper, however, says, 1 second, right? You could have a case of Yibum without inheritance. The Mishnah says about a case where a person died childless, right? Which means that you have a childless man who dies during his father's lifetime. And Rabbi Yehuda says the father inherits the deceased estate, despite the fact that the deceased brother does Yibum and marries the widow. So you see from here that there's a case of inheritance, which is not really Yibum. So again, you could argue back and forth. Rav Shlomo Zalman Auerbach also questions the Rabbi Yehuda, and he says like this: halachic pregnancy does not begin immediately following intercourse. He says this should conceivably be true with regard to other areas of halacha as well. That's, for example, right? Imagine right now you had a married woman. She cheated on her husband. Again, married woman cheated on her husband. The husband finds out and he drops dead, right? Obviously, yeah, he dropped dead. Yeah, she cheated on him, dropped dead. What happens now? She becomes pregnant. Are you going to tell me now that the child is not a mamzer? Why? Because by the time she conceived, she wasn't married. Meaning, when did she cheat on the husband? When she was married. When did they have the extramarital relationship? When she was married. The husband dropped dead immediately afterwards. He found out, he caught them, boom, dropped dead. Now all of a sudden, right, the guy comes, a day later, she becomes pregnant. You're going to tell me the child is not a mamzer? So why would it? When was the relation? She was still married. So he says, are you going to, and the other way around, an unmarried woman. Unmarried woman has a relationship with a man. And then she gets married to another man before the conception. Are you going to tell me then that according to the Yehuda, the child is a mamzer? One more time. She went the night before her wedding. She went and she cheated on the future husband. The night before her wedding, she comes, she has relations. The next night is the wedding. She goes to the wedding. That night after the wedding, the husband was too tired, whatever it was. But she became pregnant. So now when did she become pregnant? She's already married to the second husband. Are you going to tell me now that the child also is a mamzer? Such a theory appears nowhere in the Talmud, and it doesn't make sense. Because everything goes with the intercourse, not at the time of conception. So therefore, Rosh Shlomo Zalman Auerbach says, it's nothing to do with this. Right? And therefore he comes and he says, it's nothing to do with one another. So he comes and he says, what's the difference between the two cases? He says, Rosh Shlomo Zalman Auerbach distinguishes between the issue addressed by the Nod of Yehuda and the posthumous fertilization. And he says like this: since conception occurs naturally and discernibly after intercourse, halakha overlooks the time lapse between the two. And he treats the pregnancy as though it starts from the intercourse. Meaning, if there's intercourse and everything's done normally, so even though there's a time lapse in between until the fertilization of the egg, halakha looks at it as one status quo, one event. Even though there was a time lapse between them, it's one issue. And therefore, just like Rosh Hashanah said, whether it's to do with the mamzerut or all these things, it's one halakha. As such, a woman who's widowed after intercourse, even though, right, she doesn't have to do chilitza nibum. Why? Because if she does become pregnant from that intercourse, that was automatic. When the husband died, she wasn't pregnant. Doesn't matter. It was the intercourse that got her pregnant. And that intercourse applied when he was still alive. So therefore, she's going to be ptura from yibum and chalitza. However, though, artificial insemination, by contrast, is the result of human intervention. It's a separate step that needs to be taken into order for the conception to take place. Therefore, a woman who died without a child and then is artificially impregnated with a semen after his passing, she requires chalitza nibum, right? Even though she becomes pregnant with the child's husband. And that's what the Rosh Hashanah applied to the conclusion of the case. Who produced sperm during his lifetime, and then he stored it, and then they used it to inseminate the woman after death. Even though Rosh Hashanah rejected the position of Yehuda, he concludes that in this case, the woman requires chalitza yibum, even though she's going to have a child afterwards. This is also the view taken by Moshe Sternbach, which he should have a by the way. He's the head of the Dah Haradit in Eretz Israel. However, Sternbach extends his ruling even further than Rosh Hashanah. And he says, supposedly, that a child produced from man's sperm after his death, he's not considered his father. This is a chidush. Meaning, Rav Moshe Sternbach not only said that the wife needs chalitza yibum because there was an interim in the middle, and therefore there's a break. He says he's not even his father. And therefore, Rav Sternbach writes that it's likely inapplicable after a man dies, because fathering does not occur after a person dies. And although a man who dies immediately after intercourse is considered the child's father, this does not apply to the sperm that is posthumously injected into the wife's uterus. In the former case, the man is, for all intents and purposes, fathered a child before leaving the world, because he completed and performed the male role in reproduction. In the other case, the process of fathering did not begin until after death, and therefore he's not considered a father. Therefore, Sternbach concludes, remember, he's the head of the Edah Haradit, the Betin of the Edah Haradit of nowadays, right? He's the brother-in-law of Dayan Ehrenreich, the head of the London Betin, right, in England. So he concludes that with respect to all halachot, a child produced from a man's sperm after his death is not considered his father's child, which means that he does not inherit the father's estate. He's permitted to marry the father's family members. And in light of this theory, he says it's prohibited to do so, because if you're going to take the sperm from a child, from the deceased, and then put it in a woman, you're bringing up a child in the world with no halachic father. Biological father he has, halachic father, he has no halachic father. And Rosh Hashanah, however, obviously did not take this clear, he didn't agree with this. He recognized that it was the father, despite the fact that the mother still has to do chalitza yibum. So in conclusion, we're going to finish off the shiur by saying, according to the poskim who permit removing the cornea from a human corpse for transplantation in live patient, it is likely that fathering a child from sperm taken from the would be permissible, whereas those who forbid it would obviously forbid this as well. According to Moshe Sternbach, right, the child produced after biological father's death is not halachically regarded the father's child, and this procedure is forbidden because then you're bringing up a child with no halachic father. And the consensus amongst the poskim is that a child produced from a man's sperm after his death does not absolve the widow of the obligation of chalitza. She would still need chalitza. So it comes out that it's not a simple, even if they won in the court, right? You have Moshe Sternbach, you still have a lot of other, it's not that simple. Bichlal and the halakha, you saw how many poskim prohibit. Some want to permit, they would have to rely upon many things. Again, even halachically, if they wanted to permit, the way that some rabbis wanted to permit was only if you had everyone together, which means it was the will of the husband before his death. He's married and he's giving it to his own wife, to have a child from his own wife. It's considered the cornea that it's resurrecting from the dead. It's not considered the normal way of putting it back in, which means it's an abnormal use. It's less than a kazai. All these things that we mentioned, they're trying to put everything together. When you have everything together, maybe they would come and they would be lenient in such a scenario. But in this case that would actually happen over there, it doesn't sound very likely that they would permit it according to halakha, because there's so many problems and factors also as well. And as we already mentioned, right? So this is also just very, very important, just so we can actually understand the different halakhas that came out of this